Good morning, everybody. This is Kelly from Wakasa. I just want to do just our usual little welcome and TA issues if you're having. We've got Ian and I are here, obviously, and we've got Rose and Peter who are supporting us with the tech support. So if you've got questions as we go through, please feel free to use the text chat. If you're having any TA difficulties, you can also use that, and Rose and Peter are monitoring that. You also will be able to, or please mute your line. If you have a question, you can unmute yourself, or you can do that by typing into the text box. So I'm hoping people are getting familiar with the technology as we use it more and more, but if you have questions, please feel free to use that, and they will interrupt us as we go or save it to the end, sort of depending on where we're at. So thank you again for joining us, and I think we'll get started.
Great. Hi, everyone, and welcome to part 2 of our December webinar series. For those of you who joined last week, you'll remember we did touch on some of the issues that we're going to be covering today and also explain why we felt like these two topics went so well together. If you are just joining on today's webinar, last week's webinar is archived and available on our website. And also know that these two, while related, do really stand on their own, and we'll be referring where important back to the material that we presented last week. So don't feel like if you missed last week's webinar or haven't had a chance to look at it, you're going to be somehow not be able to follow. I think you'll be able to follow on just fine. So today's topic is services to minors. This is probably one of the more, it's a fairly common technical assistance question that we get here at Wakasa, and I know I field these questions sometimes, as well as some of our other staff members certainly have come back after meeting with advocates either at regional meetings or program visits, bringing these questions back. And so I think for a while we've recognized this is something we want to talk about on a more, I guess put something out in a training, put out information, and put out some of our philosophies around this issue, while at the same time recognizing that what I usually tell folks is this is a complicated issue, and it's one where the law doesn't provide a lot of answers, and I think we'll see that as we go forward today. But I think I'm excited about doing this webinar because we haven't done this. Usually I'm telling Kelly at Save Us, don't talk about minors, let's not go there. So we're going there today intentionally because I think it's we need to address it. And certainly it's something we address one-on-one in TA questions, but I think being able to talk about this in this format is exciting. So we will continue on. For those of you who have seen me train, you'll know that anytime we're in complex areas, I'm throwing these types of slides up about disclaimers. I can't get the lawyer completely out of me, but recognize, right, that we're providing legal information and not legal advice. We will be talking about agency policies and developing agency policies. Many of you undoubtedly already have those. But if obviously don't develop a policy based on the webinar, that requires more in-depth conversations. But we will be talking about some of the support or some of the guidance that is out there for agencies in this area. So we will be talking about that, even recognizing that the law is somewhat less than clear. Okay, so why is this so important? And again, here I'm assuming we're kind of preaching to the choir here, but notice that the title of the webinar is Services to Minors. We really will be focusing today on teens. I recognize that minors are kind of grouped from 0 to 17 or to 18, and we recognize there's a great difference between someone who's age 3 versus someone who's 17. So today we're really going to be focused on teens, and we'll see as we look at other areas of the law that those areas of the law also are looking at adolescents in general. So that's going to be our focus today, rather than on children or those younger than the teen years, for lack of a better word. And so why is this important? Well, we know through various studies and our own work, undoubtedly, that this is a segment of the population that experiences sexual assault and sexual violence at high rates. They experience that at higher rates than other segments of the population. And so because of that, because of the prevalence in this population, right, it's important we think about how to provide services to these individuals. And again, right, how to do that is less than clear. You know, there's not Wisconsin law does not provide a direct roadmap, so to speak, for how agencies can do this. But in keeping with that map analogy, I think what you'll find is that there is guidance that can help you get to where you want to go. And I think this is, again, kind of like we talked about last week, philosophical conversations, opportunities for agencies to think about these issues. And what I hope this webinar does is show and provide some information to help you get to where you want to go regarding services to adolescents and teens. Just a little background on the prevalence. I'm going to pull from a few different sources here, and we know that the Office of Justice Assistance, when that existed, it's now part of the Department of Justice, but they used to release a sexual assault report, and that report was last released in 2010, and it had some interesting data. And so this report, remember, is data about sexual assaults reported to law enforcement, right? So recognizing with that caveat, but they noted a 5-year trend showing juveniles are the highest victimized population, nearly 75%. In 2010, juveniles aged 15 and under represented nearly 2/3 of all victims that were reported to law enforcement, and nearly 40% of those were between 11 and 15. Right? That again is just kind of highlighting those prevalence, the prevalence of sexual assault in this population. National data, we have the National Intimate Partner and Sexual Violence Survey, or NISFIS, and that showed nearly half of all female rape victims experienced their first completed rape before the age of 18. There's also the Youth Risk, help me, Kelly, was
Youth Risk Behavior Survey.
Youth Risk Behavior, oh, it's right up there. Okay, read the slide here. Right. It's hard, a little bit hard to read, but this survey showed about sexual assault and sexual activity, percentage of students who've been forced, either verbally or physically, to take part in sexual activity in high school, this is high school students, and fairly consistent rates across the high school, and nearly 16% of female respondents identified as have been forced to take part in sexual activity. Those rates are also similar to in the Wisconsin Adverse Childhood Experiences Report, or ACE report, that 16% of adult women surveyed in that, as part of that report, identified experiencing sexual abuse as a child. So again, I think, sure, this is not necessarily new to you, but making the case that this is really an important issue. Okay, moving on to the legal considerations. So we've identified why this is important. Again, I'm sure most of you don't need convincing on that. Looking at the legal considerations regarding services to minors, the way I think about it is really there's two key issues that arise when thinking about providing services to teens. One would be parental consent, and two relates to confidentiality, right? That's the tie-in to last week's webinar. Again, we'll be reviewing some of those principles or information that we talked about then. But really two key issues. First, looking at parental consent, right? And for those of you who have talked to me about this issue, again, you know this, that Wisconsin law is silent on the issue of parental consent and providing advocacy services to sexual assault victims who are teens. So this would, therefore, as a result, right, is a huge gray area for programs, because the law just doesn't specifically state either way. It doesn't say parental consent is required, nor does it say it isn't, right? It's silence. Second would be the issues related to confidentiality. Again, remember back to last week, or for those of you just joining us, those acronyms, the VAWA, so that's the Violence Against Women Act funding, the grant conditions attached to that funding, or FIPSA, which is the Family Violence Prevention and Services Act, which funds primarily domestic abuse services. So FIPSA is for dual agencies, right? That's your agency may indeed receive that funding. That both of those sources of funding have grant conditions, right? And those grant conditions refer to obtaining the consent of unemancipated minors prior to revealing identifying information. Both VAWA and FIPSA say before releasing identifying information, you have to have the informed written consent of the individual, and in the cases of unemancipated minors, meaning, right, minors who are residing and still under the care, custody, and control of their children, you need the consent of the parent and that minor. So I think that's, we'll talk a little more about that as we move forward, but just remember that those provisions exist, and so for agencies that receive that funding, that's something you will need to think about. And again, we talked about last week, that's all the law says. It doesn't say an age. So it doesn't make a distinction between a 3-year-old and a 17-year-old. And we talked last week about the problematic nature of that. But just recognize it uses the word unemancipated minor and not an age. Now, I was saying that Wisconsin law is silent on the issue of confidentiality. And really, as I was thinking about this yesterday, it's not entirely accurate. I want to refer to the privilege statute, which again is not necessarily directly related to confidentiality in terms of releasing information, but it does talk about what is a confidential communication, right? And the definition of a victim in the privilege statute only refers to an individual who has experienced abusive conduct, right? It does not say an adult. It uses the word individual. Also, when you look at the definition of abusive conduct, that includes child sexual assault crimes, right? So recognize that our privilege statute seems to contemplate that confidential communications between advocates and victims, which could be children. Now, again, privilege really operates in court settings, right? It's a rule of evidence. Without getting too far down that road, but it's a rule of evidence about preventing information or from being compelled in court. But just note that the privilege statute does use the word individual. Looks like we have a question here. Does the SAVES grant have those restrictions as well? I would have to check. Not to my knowledge. But that would be a great question for your friendly folks at the Office of Crime Victim Services at the Department of Justice. And to my knowledge, that language is not in SAVES. I don't know, Kelly, whether you have.
I don't know.
Yeah, I don't know, and so I think that's a great question. Something that certainly your SAVES grantee administrators at DOJ. Could find out, and we could certainly something we could look into and post something as a follow-up as well. It's a great question. Okay. So what services can teens access? I think the first bullet point up there is where is kind of the first stumbling block, and it's a legitimate stumbling block that agencies run into. And when we have a lack of clarity or silence in the law, I think this is a logical place where it can give pause to us when thinking about this. And that's the general principle that runs throughout our legal system, state law, federal law, that parents retain significant decision-making authority over their children, right? That children are treated in our legal system differently than adults, right? This is true. And it does, I think, give us pause when we think about, well, how do we provide services to children, recognizing that the rules aren't necessarily the same for adults as they are for children. And I think that's a legitimate issue. However, and what we're going to do next is look at areas of the law in which there are exceptions to that general principle, right? You all are undoubtedly familiar with the legal system having these kind of general rules, and oftentimes there are exceptions, right? And just with that, with this principle, there are exceptions to that, and that there are both in federal law, we're going to focus on state law today, and in Wisconsin, there are some services teens may access without parental consent. And in some cases, they may do that confidentially. So I think it's important to recognize that while that first bullet point does give some pause, it's not an absolute, or it's not a uniform principle that teens can't access any services. However, right, while those exceptions do not address sexual assault advocacy and sexual assault services, I think they may be instructive for programs who are developing policies, who are examining their policies, or maybe even looking at them again in light of some of the information regarding the grant conditions that exist. So I think that's where we're going to turn to next, looking at some of these other services and what the law says about them. Family planning services, right? I also want to note, you'll see at the bottom of the slide, there's some source information regarding where I'm pulling this information from, so you can see that there. It's a fantastic document released by the Department of Public Instruction. It's called Confidential Services Available to Youth in Wisconsin. That's where I pulled much of this information, so I want to thank DPI for their work on this. It's a really helpful document. It was really helpful for me in organizing my thinking and how I wanted to kind of present this information to you today. So just a plug for that. But regards to family planning services, Wisconsin Family Planning Statute states that clinics must treat all information gathered, which would include identifying information, as part of a confidential medical record, and that no distinction is made based upon age. Additionally, there's Wisconsin's Medicaid Family Planning Waiver, which allows individuals who are at least 15 years old to receive some limited family planning services. Just a little side note about the Family Planning Waiver, that is an income-based service. However, the parent's income should not be included in determining financial eligibility for those services. There's also support in Wisconsin's mandatory reporting statute for teens receiving confidential health care services. And those health care services are defined as follows, right? Family planning, obstetrical health, treatment for STI, right? This is probably not new information, but there are exceptions built in to our mandatory reporting law, even saying these folks here, right, healthcare providers defined up on the screen, do not have to report when providing those confidential healthcare services, right? Now, we know that that exception is not absolute, right, and that there are certain situations in which, you know, despite the exception, a report is required. The old exception to the exception.
I was going to say, it's an exception to the exception.
It is an exception to the exception.
Darn lawyers.
Right, and so if the contact's with the caregiver or the child is unable to consent, you know, a report is still required. However, right, even built into our mandatory reporting law is a policy judgment by our legislature, right, that in certain circumstances we believe, or our state believes, it's important for teens to receive certain services without fear of disclosure, right? Built into our mandatory reporting statute. School services. Voluntary disclosures by a student of alcohol or drug use to educators may not be disclosed without the student's written consent. Again, there's some limited exceptions there. Second bullet point, we've already talked about that reproductive health services related to a school nurse are confidential. And lastly, personal records of an educator or psychological treatment records are not pupil records and available to others, including parents. Again, those coming right from that DPI document. AOTA services. When we say AOTA, right, we're referring to alcohol and other drug services. Juveniles age 12 or older may consent to some limited services without parental consent. So here, we notice the age of 12, that we're talking even maybe, I don't know, younger than, it's not 14 or 15, we're talking, 12 years or older, are able to consent to some limited services. An example of some of those services might be preventive services, diagnostic services, assessment, evaluation. And that information about those limited services may not be disclosed without the written consent of the juvenile. Just as a side note, this is an issue when I was working at a program. Prior to coming to Waucasa, I was an attorney advocate at one of our member programs. And as we were wrestling with this issue, I was doing a legal research and was noting that I came across this, this statute, and really informed our thinking about it. That there were the abilities of, or there are the abilities of children age 12 or older to access some of these services, right? HIV test results. Again, notice the ages are not uniform, right? 14, 12, sometimes there's no age. 15. HIV test results of teens age 14 or older may not be disclosed without the juvenile's written consent. Again, some limited exceptions. Services for runaway youth. And the first bullet point is really talking about services, not housing. And that housing or housing runaway youth are really covered in the second bullet point. But that parental consent is not required for youth to access crisis intervention services from those programs. And that the information may not be disclosed without the youth's consent. In terms of sheltering a runaway, runaway homes may shelter youth up to 12 hours without parental consent. And after that, the runaway home must notify a county intake worker who would eventually notify the parents. But again, that's really talking about housing youth, and for the most part today, we're talking about services independent or outside of providing that actual housing, right? I'm really thinking of advocacy services, not necessarily sheltering a minor, right? That's certainly very different. For more information on that, I definitely, if you have questions about that, would want you to connect with our sister coalition, NWS Wisconsin. They have some resources about that. But just wanted to put that caveat out there that I'm really talking about services not related to housing. Okay, and then last is mental health services. And mental health services, generally speaking, right, minors may not access mental health services without parental consent. The age of 14 does have some significance for these services. But it's not a ability to access them without parental consent, right? That with some exceptions, teens, 14 years or older, may have a right to a hearing if the mental health services are provided without the juvenile's permission. So again, recognizing some autonomy, but it's reviewed by a court, right? Or in other situations, if that teen who's 14 or older wants outpatient services, but the parent doesn't agree, they can petition that for a hearing by a county mental health review officer. Again, much more limited autonomy for teens seeking mental health services. Now, I just want to note, here I'm really referencing outpatient mental health treatment, and that's defined in the statutes. In Chapter 51, it means outpatient mental health treatment means treatment and social services for mental illness. Mental illness means a mental disease to such extent that a person so afflicted, this is the statute's word, it's not mine, requires care and treatment for his or her own welfare, the welfare of others, or the community. So I do want to note, right, when we're taught that mental health treatment and mental illness, those have legal definitions. And I certainly know that some of our programs may provide some of those services. But I want to make a distinction between mental health services and advocacy. I don't think they're one and the same. I don't know if you have anything you want to add. Okay. Yeah. Okay. So that's an overview of Wisconsin law as it relates to the ability of teens to access certain services, right? And so we can see throughout those areas there are exceptions to that general principle we stated up front, which is, right, parents retain significant decision-making authority for their children, over their children. So one of the things that we've looked here at WCASA is, well, what do other states do about this? Have they answered this question? And, you know, as you might expect, that some have. It is certainly not a uniform approach. But in doing research in this area, one of the states we looked at was New York. And New York, I think, has pretty definitively answered these questions. And New York law in this area basically states the following. It allows minors to access sexual assault services provided they can give informed consent. Now note, they don't set a minimum age at which a minor can give informed consent. So there's some ambiguity even in that statute. But that's a fairly, I would say, a fairly progressive statute. And they even say that in situations where the parent has consented to the services, that information may not be disclosed without the minor's permission, right, with limited circumstances or limited exception. And if that child is 12 or older, if they object to the disclosure, the program may not reveal the information. So, you know, that New York, in my estimation, is, you know, could be an example of, I think, what I would think is progressive legislation and progressive laws in this area, and certainly would, I would say, give guidance to programs if we had something similar. We don't, of course, but I'm just putting it out there as an example of a state that has looked at this and made some, I think, fairly progressive decisions, and, you know, wanting to recognizing the importance of providing services and then giving guidance on it. Okay, so what does this mean for Wisconsin, right? Well, there is no law on the books that prohibits services to, when I say unaccompanied minors, I'm really meaning individual teens who are not accessing your program services with their parents, right, with the parental consent. There's no law that prohibits services without parental consent. But, or however, or and, right, keep in mind that general principle, right? And I think I understand why we have pause in this area. And the silence is not the same as an affirmative permission to do so, right? So, thinking back to, you know, the two legal issues that I outlined when talking about this, parental consent and services. Agencies and programs are going to have to determine that. Are you going to require parental consent before you provide services? Your agency may have answered this, and obviously that's a decision you've reached. But if you haven't, that's something I think you're going to have to definitively answer as much as you can. And we'll talk about some considerations in a few minutes. But I just want to ask a question about, and you can use the chat box here. But what are the risks about providing services to minors, and what are the benefits? And so just take a minute and use the chat, and we'll call out some of the answers.
We'll give people a second
Yeah.
just to figure out where their chat is and where they can type those answers.
We have a risk. Parents wanting to know conversations between advocate and team.
All right, it's a great question, and we're going to absolutely talk about that. I think that is probably, as Kelly and I were preparing, it's probably one of the things agencies worry about the most, and I think certainly for good reason.
I think a benefit goes back to some of the prevalence, and I think we're seeing more and more some pretty high-profile teens, sexual assault cases involving teens, and we know that it's spilling into social media, and we know that it's impacting peer relationships at schools, and so I think these sexual assault issues that teens are dealing with are really complex, and so we know in addition to the prevalence that Ian sort of laid out at the beginning, in addition to that, there's some really complex, some complex dynamics that go along with teen sexual assault, even outside of whether or not to provide services. I think the cases can get pretty complicated, and we've seen some really horrific examples of teens not being supported and not getting services, and resulting in some pretty horrible outcomes for them. So I think in terms of benefits, helping to intervene and work through that and support teenagers is really important.
We have 3 more comments. The first is not following through the service. They might feel alone.
Mm-hmm.
Benefits are they might open up more. 2, benefit, the child doesn't have to be afraid of getting in any sort of trouble.
Yeah.
And 3, benefit, someone to listen and advocate for them and believe them, same as adults.
Awesome.
Great point, and that's something that we talked about a lot, Kelly and I, in terms of preparing this, that while the law makes distinctions between children and adults, the impacts of sexual assault aren't any different, and that I think what that person nicely talked about was, the benefits would be for teens and adults are the same of advocacy services, right?
We have 1 or 2 more.
Okay.
Risk separating families if an offender is a family member.
Mm-hmm.
The benefit, providing services to minors who are at the highest risk of sexual assault. They may not be able to tell their parents if the parents are very religiously conservative and the minors know the parents may be unsupportive or engage in victim blaming.
Yeah, exactly.
Right.
All right, really good thoughts and points. Thank you all for sharing. Okay. So what about confidentiality, right? The second legal issue that I identified up front. Well, I do want to keep in mind mandatory reporting requirements. I certainly understand that some agencies and some of you on the call may be statutory mandated reporters, right? And obviously that impacts your ability to offer confidential services, right? If you are a mandatory reporter by statute, that means you have an affirmative duty to let someone know, and that someone, right, by law is CPS or law enforcement. So keep in mind that, and that second bullet point is really an important one, that with respect to mandatory reporting or any limitations that your agency may have on confidentiality, whether by agency policy or statute, right? If you're a mandatory reporter, should always be explained to teens prior to providing services, right? You don't want to pull out the rug from under someone and, say, I'm sorry, now I have to tell someone, when that information might have impacted what and how they disclosed.
Yeah, I think this often comes up for folks too that are maybe doing outreach and education in schools. I mean, that's an important time to talk through some of that. And I think while when we say that a lot of these questions come to Ian, I know that Rose and I get them on the prevention side of things as well, because they're the folks that are having more contact with minors through their education in the school. So again, I think it's just really, really important, particularly when we know we have a population who maybe is feeling maybe not supported, particularly by adult systems, that we're really upfront with our limitations and finding ways to communicate that in a way that is still supportive and understanding of their needs.
Looks like we have a question. The question is, what is the statute that states who is mandatory reporters? Oh, 48.981, I think, is the statute. Also, remember that WCASA has an information sheet on this topic that is current and up to date. It's on our website. We'll outline who are mandatory reporters. We also talked a little bit about that at the last webinar, but just as a reminder, sexual assault, domestic abuse advocate is not listed in the statutory definition or statutory the statute regarding who are mandatory reporters, right? Thank you for the question. And last bullet point, right, refers to information we talked about last week and also earlier on. That what do our federal funding grant conditions say? They say you need the informed written consent of the minor and the parent before revealing identifying information. So I think that's a policy judgment by OVW and those who, our federal government created FIPSA, that you need permission from both of those individuals before revealing identifying information. This question came up last time, right? And it's come up in the chat as identified as a risk. Absolutely. I think this is a real huge issue for programs. So I certainly understand that. And this is where I think the lack of clarity does present us with challenges. Just like with parental consent, I think this is the area where the lack of clarity poses some challenges. But remember, right, I would say that those VAWA and FIPSA grant conditions state you need, before revealing identifying information, you need the minor's consent. Now it's the consent of the minor, unemancipated minor, and the parent. But it's not just the parent. So I think there's support there that that information, if you're subject to those grant conditions, you not reveal information without the minor's consent. And then lastly, that both of those funding streams contain information, or contain provisions, I guess, that consent to the release of information cannot be given by the abuser of the child or the other parent. So I think, you know, these grant conditions and these confidentiality provisions provide support for agencies to not reveal information without the minor's permission.
And one other thing we talked about on the previous webinar that I think is important along with this is that, you know, we talked about particularly VAWA as a best practice in terms of how we are delivering services, how we're communicating about that. So I think that in addition to, you know, we kind of laid that out and said you may or may not be VAWA or FIPSA funded, but it's, if you're not either, it's still something to look at in terms of a best practice in how you're delivering services.
Exactly. Okay. So what are some practical implications of this information for agencies? Well, one, and this is, again, you know, if you've heard me talk about this, you know my philosophy is that, you know, agencies should have a policy on services to minors. Whatever it be, you know, have something committed to writing that you're going to follow, and develop a policy that reflects your judgment on this and what are the parameters regarding how you will provide services. And that policy should address issues of parental consent and confidentiality. The third bullet point there relates back almost to that question of what happens when, if a parent wants to access information. And something that Kelly has talked about, and I want to bring her in a second here, is when possible, provide an additional advocate for that parent as a secondary survivor, as a way of maybe helping with some of that, that both are getting services and both have confidentiality. I don't know if you want to talk a little bit about that from your experience.
Sure. I think that, I mean, I'm a parent of a teen, and so I can relate to some of the protectiveness and the wanting to be involved in the process. And so I think if you're trying to, if you're in a situation where you're responding, either they've come, a teen has come to your office and the parent is there, or you're doing a medical accompaniment, that's oftentimes when we ran into it. And it was hard to sort of separate the parent and the child, and we didn't want to obviously do that in a forceful way, but we also wanted the teen to have some ability to talk to an advocate on their own and get some information. And what we found the best way to do that was to call out another advocate. And of course, I worked at an agency that had the capacity to do that, to call out a volunteer or even another staff person to come in and to say, like, in the same way that you do with the primary survivor, introduce yourself, offer your services, and then we had resources and materials for parents about how to talk to your kids about what happened and how, what might be some of the things that you're experiencing as a parent, as well as what you're experiencing on behalf of the trauma that your child has experienced. So I think that not only is that a really important service, it's also a really nice way to really talk about confidentiality and to say to that parent, like, this is why we do this. So your child has their own advocate and you have your own advocate, and you both have confidentiality with that advocate. And then, someone referenced in some of the benefits and challenges some of the victim-blaming responses that sometimes come from parents. And what we found is that we know that a lot of people don't respond really well when trauma happens, and parents aren't unique in that. And so when you have the space for a parent to process separate from their child some of those initial maybe victim-blaming things, that it can help with that parent-child relationship as well, so that child never hears those things, and the parent can process that with an advocate and then move on to being a good support system for their child.
All right. Thanks, Kelly. We've got a question.
I can understand the limit on types of services, but why would there be a limit on the number of visits by the minor?
Oh, yeah. I mean, I hadn't got to that yet. Those are what I had put up there were just some examples of things you might want to think about. They are not. They're not. I don't know. Recommendations is the right word. They're just. There was a way. What I often feel frustrated by is when I'm answering this is I feel like I don't give a lot. It's hard for me to give a lot of clear, concrete information. I think that's what's nice. Hopefully, you found the webinar helpful in terms of grounding us in the legal landscape, but wanting to give some guidance, some things programs could think about. So one thing your policy could think about would be, is there going to be an age at which you are going to, below which you would, if you do provide services to a child, you are going to require parental consent, right? Think back to what we talked about, 3 versus 17. I'm using those kind of extremes, but right? And so that's something to think about. A limit on the types of services. Maybe you think that you'll be able to provide some services, but not all services in terms of without parental consent. The number of visits was just an example. It's not meaning you need to do that. Maybe your policy says, you know what, we'll provide services without parental consent for 3 visits, after which we would get parental consent, right? Allowing, some of the advocates I've talked to about this, and we're going to come to this, and I want Kelly to chime in, but that might allow you to develop a rapport and a relationship and with that team, and to talk about the importance of them talking with their parents, or to explore what are the barriers regarding them wanting to disclose to their parents. So that's just an example. It's not put up there to mean you must have a limited number of visits. It's just something to think about. some other practical implications, and I want to hear Kelly's thoughts from her experience here as well. But just quickly, when providing services, explore with the teen their fears regarding talking with their parents. Perhaps obtaining parental permission will not be as onerous as you originally thought. In which case, then, if you have parental permission, right, you're in solid ground, right? And that if parental consent is obtained, thinking back to what Kelly was just talking about with respect to those services, if possible, for a secondary survivor, the parent and the teen, the importance of confidentiality. I don't know if you have thoughts about these things, Kelly, from your experience.
Yeah, I think generally speaking, and I don't want to overstate that it happened all the time, but a lot of times when working with teens and doing exactly what that first bullet point said, talking through what their fears were, sort of exploring who their support system might be, as we do with all survivors. Once teens had sort of someone that they felt was on their side and someone that could support them, they wanted to talk to their parents about it and get some support from their parents. Maybe not immediately, but eventually, and I would say in the cases that I'm trying to recall, where that maybe wasn't the case, there were significant reasons why there were not. There was, other family violence happening in the home where there was a safety risk for that teen, for their parents not to find out, or they wanted to tell, but they wanted to wait till the following week, or there might be some more practical things in that way. But generally, once I had those conversations and talked about the importance of support, developing a support network and talking about what their options were, and it's like once they sort of had someone on their team that could help them tell their parents, and then we would talk about that process. We talk about how we can bring in another advocate, and that advocate can have some conversations with your parents and talk through their feelings, because they're going to have feelings about this as well. And so most often we sort of got around this just in exploring those fears and really trying to discuss support networks and figuring out what was the best what was the best interest for that team.
Yeah, and certainly in my experience with this issue and talking with advocates from around the state, they have echoed similar things to what Kelly just talked about, that those conversations with the teen about their parents and what are their fears about that, and the advocates offering to be of assistance in helping navigate those barriers. And maybe that's the advocate being with the teen when they disclose, whatever that might be. That is a core part of advocacy and might lead you to the position of where you end up with parental permission for that, in which case then really you're not as much in that gray area, right? You have that, in which case then some of this uncertainty goes away.
And I think going through the how you do it with the survivor as well can be really empowering. Like, how do you want them to come here? How, we can talk together, and then we can sort of separate and have, parents go with one advocate. Really in terms of making a plan of how to do that that's in the best interest of that teen can be a helpful process for them as well, so they feel like they have a little bit of control over the telling, and as well as some safety, and having somebody else there. The other thing I think that's important to mention, sort of related to that last point, is that another benefit of providing those two advocates is that if the parent then is calling back to get information, and if I'm the advocate of the child, I can say, let me connect you with Ian, who's your advocate, and being able to sort of separate that, because even if you have permission, that doesn't mean you throw confidentiality out the window. So even if the parent has said, yes, please provide services to my child, that doesn't mean that if that parent's calling for information that you should be giving up that information. That goes back to what Ian was talking about, the signed releases and some of the things we talked about in the last webinar as well. So just because you have permission doesn't mean you share everything with them.
So just, in summary, and many of you have, but, we certainly believe programs need to make decisions about services to minors, and that those decisions and those policies address some of the issues we've talked about today. And then, again, right, this is a segment of the population that does need services due to the prevalence of sexual assault amongst teens, and that while Wisconsin law is silent on this and on the specifics of how to do this, keep in mind the information we presented today that outlined the ability of teens to access certain services without parental permission and to do so confidentially. Again, not specific to SA programs or dual sexual assault, domestic violence programs, but recognizing that there is that guidance out there that can help agencies and programs get to where they want to go by looking at what the law says in other areas as kind of a roadmap, right? It's not going to get us the direct answer, but I think it is illustrative. And I know we've had questions come up, and thank you for those. If there are other questions, we'll pause for a minute or two to give folks time to chat and to write in. So why don't we do that before wrapping up? Last thing I would say is, obviously, myself and Kelly and our staff are available. I'm certainly happy to take questions on this. So, it's not your only opportunity, but let me just pause for a second to give folks a minute if they want to chat in.
All right, question. Would it be improper for the minor and parent to have the same advocate, even if they are both informed about the conflict and informed about confidentiality?
I mean, legally, there's nothing addressing that. So I would kind of defer to what, on a practice point, Kelly, what your thoughts about that are.
Well, I think it's going to depend on your organization. Like, I realize in some organizations you have a single sexual assault advocate, and you're maybe not going to want to utilize volunteers for sort of ongoing, you might be able to utilize a volunteer in the initial call out if you're doing accompaniment, but you're not necessarily going to want to use that person for ongoing services. I think the reason I recommend it is I remember being in those positions where if you're providing, some pretty regular kind of ongoing crisis intervention and advocacy services, you sometimes forget who told you what and who knows what, which can sometimes be a little challenging. And of course, this isn't the only, survivor and family you're providing services to. So for me, it was just it was a good organizational decision that we were able to go that route. To sort of, to help the advocate sort of with like, okay, did the teen say that when mom was in the room, or did she say that after mom left the room? And, just, I think it could be challenging to navigate. And also when there's some of that separation, you're able to talk to the teen to say, okay, do you want me, what do you want me to share with you? If anything, what do you want me to share with your parents? Because sometimes they do want you. Can you just, can you tell my mom and dad X, Y, and Z? Okay, well, what, why do you want me to do that? Can we do that together? But I think that for me, just logistically, that separation was helpful.
Another question. When it comes to informing the individual about making a report to social services, do we need to contact the parent as well as the unemancipated minor? If we do, what if the parent is the accuser?
Okay, it's a good question. So if you are a statutory mandated reporter, we covered this last week, so just want to remind folks, then you do not need permission to make the report, right? VAWA and FIPSA state, well, let's not talk about FIPSA right now. Otherwise, we're going to go right back to, look at last week's webinar would be one, but let me try and answer that directly. There are exceptions built in to VAWA that state you do not need permission, written informed consent, if you are required to make a report of child abuse and neglect by law. So, and that report, by statute, is to law enforcement or CPS. We can infer that parents may ultimately find out, but the report under Wisconsin law is to law enforcement or CPS, and no, you do not need the informed written consent of the person if you are a statutory mandated reporter, if you are in that list, okay? Yeah. I mean, I think certainly this is something that we put up other states, and that was something that a couple summers ago we had a legal intern. I had a legal intern do some research. Obviously, because this issue keeps coming up, and because of the lack of clarity, this is a policy issue that is, on our radar screen, for lack of a better word. Questions of timing and how, those are all, important questions and really not the scope of today's presentation. But, the fact that we had that research done, we would probably want to, update it, does not mean that this is, or reflects our belief that this is important, that I think it would be helpful for programs to have some guidance in this. We recognize that the legal landscape being less than clear is hard for programs. Operating in the gray is hard for programs. On the other hand, you do that in areas beyond just services to minors, right?
I was going to say, we're advocates. We love the gray.
Right,
That's the day-to-day stuff.
But, I do want to let you all know that certainly this is an issue that WCASA is interested in the policy front. The details and the when and the how are important, but yes, please understand it's not something we're not thinking about. Were there other questions? All right. Hearing no other questions, I want to thank you all for attending these 2 webinar series. I hope you have found them informative. Please know that you can contact myself or Kelly for other questions or more specific questions that you might think about after participating in these webinars. And we're available for technical assistance. And yes, thank you all, and have a good rest of your day.
Happy holidays. Thanks for joining us.